Peace and blessings. Salutes everyone here tonight. Welcome. Tonight, we're going to commemorate our brother, Mumia Abu-Jamal. We're going to honor the lineage and the legacy of our resistance to oppression in Black August. Black August, as you know, originated in California penal system, and it was to honor our fallen comrades and freedom fighters, ancestors, Jonathan Jackson, George Jackson, William Christmas, James McLean, and Katari Golden. Tonight, what I want to do is ground our continued struggle to free political prisoners, free Abu-Jamal, in the context of our resistance in the city of Philadelphia, particularly, right? And in that, I want to highlight the historical roots of Philadelphia, historical and cultural roots of Black Philadelphia, roots of Black resistance in Philadelphia, the historical roots of the Black Bottom, Philadelphia's Black Belt, Black Panther Party, the Black Unity Council, Black Liberation Army, MOVE, Mumia Abu-Jamal, the targeting of Black Philly for mass human caging, long-term sentences, for example, death by incarceration. Pennsylvania's political prisoners and POWs are from Philly. Philly is a center of gravity for social change in this country. Philly has a megaphone, raising the intensity and volume of the campaign to free political prisoners in this city, especially, has the potential of sending a strong signal to the rest of the country. We have the capacity of building national and international solidarity to bring pressure to bear on this city and the state's gatekeepers. So we want to make sure also to lift up the work of the Abolitionist Law Center, which is situated in that continuum of abolitionist tradition and resistance to oppression. The first European settlers in the city of Philadelphia were Swedes who set up shop at the mouth of the Schuylkill around 1643. Swedish, Dutch, and English merchants set up trading posts on Lenape territory, that is throughout the Delaware Valley. The colony or city of Philadelphia was founded in 1682 by William Penn on the Crown Province of Pennsylvania between the Delaware and Schuylkill rivers, right? He was a Quaker pacifist, Penn was. He signed a peace treaty with Lenape chief Tamamen, and this treaty was supposed to establish a tradition of tolerance and human rights. Well, just 2 years later, 1684, after this treaty of human rights was signed, the ship Isabella landed in Philadelphia carrying hundreds of enslaved Africans. You know what became of every one of the 500 or so treaties, white colonial settlers, and every single treaty our maroon ancestors into with the settlers and enslavers who constantly pursued them to bring them back under the yoke of slavery. All those treaties were broken. We know that peace treaties, what they meant. And it meant that if you were Indian or African anyway, you won the peace but lost the war. Tensions over slavery, especially among local Quakers, resulted in the 1688 Germantown Petition against slavery, the first organized protest against slavery in the New World. It was a city with a strong abolitionist pulse, Philadelphia. The Johnson House historic site in Germantown is the only known underground railroad station that operates today as a museum. It's said that Harriet Tubman stopped there to deliver folks to freedom, to what was as free as a Black person could be in this country at the time anyway. Today, the Johnson House today is directed by an unassuming, unsung, and underappreciated mover and shaker in the city, a sister by the name of Cornelia Swinson, or Sister Connie. She's been a central organizer of the annual Juneteenth, which, as you know, celebrates the Emancipation Proclamation and was instrumental in getting the governor to sign legislation designating June 19th as Juneteenth National Freedom Day in Pennsylvania, a state holiday. But enslaved Africans arrived in the area that became Philadelphia as early as 1639, brought by European settlers in the 1950s and 60s when the slave trade increased due to a shortage of European workers. 100 to 500 Africans came to Philadelphia each year. In 1765, there were about 1,500 Black Philadelphians. Of these, 100 were free. By the time of the American Revolution broke out in 1775, 1/12 of the roughly 16,000 people who lived in Philadelphia were enslaved Africans. It became one of the biggest shipbuilding cities in the country. So it might be safe to say that Philadelphia was also the seat of America's imperialist power. The site of the First and Second Continental Congresses and was the country's temporary capital after the American Revolution. This city, Philadelphia, is considered the birthplace of the United States. It's the city where the Declaration of Independence was drafted and signed. It's said that after the Civil War, Philadelphia's government was controlled by a corrupt Republican political machine. By the beginning of the 20th century, Philadelphia was described as corrupt and contented. The country's first jail, Walnut Street Jail, was built in this city in 1790. And its first penitentiary, Eastern Penitentiary, was built in this city in 1821. In 1954, our very own Black Prince Malcolm X established the Temple number 12 in the First Nation of Islam Temple in Philadelphia. The Black Unity Council was formed in 1968. RAM, Revolutionary Armed Movement, was active in the city at the time. The Black Unity Council had about 30 regular members from Southwest Philly and Germantown. 2 years after the Black Unity Council was formed, it joined with the Black Panther Party, which had established itself in the city around that time. And by the way, the Black Unity Council was founded by our very own, the late Russell Maroon Schultz. On May 31st, 1973, JoJo, Joseph Bourne, and Fred Muhammad Kafi Burton is said to have entered the warden's office at Holmesburg City County Jail to meet with the Muslims, to meet with the authorities there about Muslims being mistreated in the jail. The end result was the death of the warden and the deputy warden and the critical wounding of the captain. John Africa founded MOVE in 1972. John Africa and MOVE taught the inherent value of all living things. Much like the Nation of Islam accepted people with all sorts of past, MOVE accepted people regardless of their past. The organization protested animal cruelty in zoos, the educational systems, and police brutality. A member of the Philadelphia police revealed that between 1972 and 78, 193 arrests of MOVE members and 93 subsequent court cases occurred. And like Matef Hermech so eloquently stated in his piece, Black Power Afterlife, in his presentation at the We Are Maroon event, he said Greta Thunberg did what she did. She became, she ended up on the face of the Time magazine's cover as Person of the Year. And for the very same thing that she did, MOVE did in the 70s, and they went to prison in fiery graves for it. Francis Lazaro Rizzo Sr. was an American police officer and politician. He served as Philadelphia Police Commissioner from 1968 to 1971 and Mayor of Philadelphia from 1972 to 1980. He was a member of the Democratic Party until 1986 when he switched to the Republican Party. Rizzo presided over one of the most brutal anti-Black police regimes in the nation's history. In the 1970s, he famously told Philadelphia voters to vote white. He set the tone immediately after becoming police commissioner in 1967 as officers set upon thousands of high school students who were demonstrating at the Board of Education. Some witnesses quoted Rizzo as saying, "Get their Black asses." This is the kind of context from which emerged a young fiery brother by the name of Wesley Cook. At the tender age of 14, but hardened by circumstances beyond his control, protested against a rally for presidential candidate George Wallace. Yeah, we're talking about the George Wallace that Martin Luther King Jr. described as the most dangerous racist in America at the time. But young Wesley Cook was already in battle with Rizzo, so he wasn't daunted by going up against Wallace or any other brutal racist. Still, young Wesley was arrested by the Philadelphia police for his participation in the protest. That didn't deter him, though. In 1968, still at the age of 14, he became one of the founding members of the Philadelphia Black Panther Party, committed to African-American empowerment and self-defense. He worked for a quick minute at the Black Panther Party's newspaper in Oakland, California in 1970 at the age of 16. Then, shortly after that, he returned to Philly. Something else young Wesley Cook did at the age of 16 was he legally changed his name to Mumia Abu-Jamal. In the 80s, while still in his 20s, he took his ongoing critique and expose of Rizzo and his ruthless, racist, Blue Guard, and their brutalization of Philadelphia's Black community to the airwaves. He became a radio personality. He was actually a regular voice on WDAS. He became president of the Philadelphia chapter of the Association of Black Journalists. His voice could be heard on many radio stations. In 1981, Mumia, who had become one of our community's voices of consciousness, carrying on the Black prophetic tradition of raising community awareness, was arrested for the death of a police officer. We know the case. We know all the evidence points to him never committing the crime, or else he would never have gotten off a death row. We can find the words, or who can find the words to describe the tremendous blessing to have the remaining members of the Move 9 be released, Maroon being granted compassionate release, and being able to make his transition amongst his loved ones, Arthur Chedawayo Johnson, after spending 51 years in prison, being released, Kerry Shakabuna Marshall being released, Robert Jones receiving compassionate release before he unfortunately met his demise, all at the fighting hands of the Abolitionist Law Center, continuing in the tradition of David Walker, probably one of the fathers of the dismantlist tradition. And by the way, David Walker made his transition on this day, August 6th, 1830, at the age of 33. We continue in the tradition of our resistance, our lineage, our political lineage of resistance to freedom all, to dismantle the carceral state. And we ground this important conversation today about ending death by incarceration and making a tribute to Mumia in the legacy and tradition of Black August and our freedom fighting ancestors, our Maroon ancestors. And with that said, I pass it on to
Abolitionist movements grow. Dear sisters, brothers, and friends, we come together today to salute the Abolitionist Law Center and their work against DBI, or death by incarceration, in Pennsylvania. They've been hard at work yesterday, today, and will be doing so tomorrow until it gets done. Determined to end DBI, the Abolitionist Law Center legal director, Bret Grote, its executive director, Robert Saleem Holbrook, and its staff, my co-editor, Jennifer Black, who recently released our new book, Beneath the Mountain, and journalism professor Linn Washington, are working together, in my case, among others. We thank you for all that you do. In my case, and in all cases, your work makes abolition a reality. May this movement only grow. With love, not fear. This is Mumia Abu-Jamal. Thank you.
These commentaries are recorded by Prison Radio. We're going to now move on to a question and answer segment with Bret Grote, the legal director of the Abolitionist Law Center, and Linn Washington, a noted journalist from Philadelphia, someone that has been covering the Mumia Abu-Jamal case literally from day one, if I'm correct. So with that, we're going to transition to these two to talk about the legal aspects of Mumia's case. And I just want to share that we appreciate everyone for joining us and being patient while this program was a little late due to the technical difficulties. One of the things we want to do is thank everyone for coming, and also we want to thank all the movements around the world that have been advocating and fighting for Mumia Abu-Jamal for the past 50 years. This segment here is to ground and share out on the legal strategies and advocacy strategies that we are going to be taking to free Mumia Abu-Jamal, but we want to make clear that we are not alone in this fight, and there are many others who have been fighting this fight as long as us, and if not longer. So with that, I'm going to transition it over to Bret Grote and Linn Washington. Linn, the floor is yours, brother.
Thanks, Saleem. It's a real pleasure to be able to speak with Bret. He's been fighting so long with this case that's listed worldwide as a wrongful conviction. And when we say worldwide, you kind of miss the nuances. I mean, there's people in villages in Ghana and in towns in Japan and London and places like that, all advocating for Mumia. Bret, if you could, the current procedural posture of the case is now on appeal. There were some very substantive issues that were raised at the Philadelphia court level. They were indignantly rejected. We can talk about that. But could you give us a little overview of where the case is, and then we could, dig down into the case a little bit?
Certainly, thank you, Linn, and very honored and privileged to be here with all of the panelists and especially following the comments from Mumia. So right now we have filed along with co-counsel and lead counsel Judith Ritter and Sam Spitale, the legal director of the NAACP Legal Defense Fund. We have an appeal pending in the Pennsylvania Superior Court from a post-conviction relief act petition that was filed in 2021. This petition is based on newly discovered evidence that was uncovered in boxes that were discovered in the Philadelphia District Attorney's Office, purportedly by District Attorney Krasner himself, along with other members of his staff, and they were turned over, and they contained evidence which supported new claims, which we'll be getting into a discussion of. That petition, based on those new claims, could not be filed right away because of another appeal that was working its way through the courts, challenging former Pennsylvania Supreme Court Justice Ron Castile's sitting on Mumia's appeals throughout the 90s and afterwards, despite having been a prosecutor in the efforts to execute Mumia. So once that appeal against on the Castile issue was over, the new appeal was filed, and it was dismissed by then President Judge Clemens. And so we've taken appeal into the PA Superior Court on those issues. And this is a post-conviction relief act petition. So one of the few ways you can get back into court for a conviction that is as long-standing as Mumia's is you need newly discovered evidence. And that is what what was found in these boxes.
Could you tell us what that new evidence is? There's two very compelling aspects that go to the core of the unjust conviction of Abu-Jamal, and they also touch on very, should we say, pillars of what the American justice system is supposedly built on. One dealing with prosecutorial misconduct regarding evidence and withholding evidence, and the other deals with discrimination or the appearance of discrimination and selection of the jury. So if you could give us the legal insight on that.
Yeah, absolutely. So just a little scene setting first. In Mumia's case, there are basically three types of evidence that the prosecution put together and fabricated in large part in order to secure the conviction. First, there was alleged eyewitness testimony from Cynthia White and Robert Chobert, both of whose testimony has been very thoroughly attacked and undermined and discredited over the year in the courts and outside of the courts. We're going to be focused on Mr. Chobert's testimony. These two witnesses claimed that they saw Mumia run across the street, shoot Officer Faulkner in the back, and then stand over him and unload the rest of the bullets in his 38, but only striking Faulkner one more time. And I know, Lynn, you've done a lot of work over the years pointing out how that doesn't match the physical evidence of the scene. Those two witnesses, the prosecution also tried to bolster by two other witnesses who claimed they saw somebody running across the street, but neither of those two witnesses identified Mumia as having shot Officer Faulkner. And there were other witnesses who saw other people on the scene, who saw people flee from the scene as well. So that's very important. Then there was this fabricated confession that nobody reported having heard until more than 2 months after the shooting. A police officer, it was later revealed after a meeting with the district attorney who was prosecuting the case, Joseph McGill, he asked if anybody had heard a confession. It's a very leading question to ask more than 2 months after a confession was allegedly blurted out at the hospital. And that's how they came up with a confession. They had another hospital nurse to back this up as well. She had made no contemporaneous reports. That has also been thoroughly discredited in ways we can get into in detail if we want to. And then Mumia's gun was also found on the scene, but there was no evidence that that weapon was fired that night or that Mumia had fired a weapon. And they're very simple tests to conduct to determine if that happened, leading to a very plausible inference that these tests were, of course, done, but they did not produce any evidence. So Robert Chobert was the centerpiece and the star witness. He was a 22-year-old at the time, a taxi driver who said that he was parked behind Faulkner's car when this happened, and he looked up and saw the shooting. Cynthia White was the other alleged eyewitness, and she was thoroughly impeached at trial. She was a sex worker. She had 38 arrests prior to this incident after she pointed the finger at Mumia through multiple shifting statements to fit the police narrative. She was no longer arrested. Many people have come forth over the years alleging that she was not present at the scene, that she was being intimidated by the police. Also, all the trial witnesses that were on the scene did not see her there. So Chobert's testimony is absolutely central. And what was found in the box in 2019 in the district attorney's office was a letter from Robert Chobert to prosecutor Joseph McGill, the trial prosecutor, asking him where was the money that is owed him. He said he was writing a letter to find out about the money that was owed him and that he would sign anything he needs to in order to collect that money. And he also wished McGill luck on, or hope that he had a good vacation, which was the week before, indicating they'd been in recent contact. So this is pretty damning evidence of bribery of the star witness. The other key piece of evidence being challenged in the Superior Court were the trial prosecutor's notes during jury selection, in which it shows that he was keeping track of potential jurors by race with the letters B and the letters W, and he was keeping track of various pieces of testimony from each potential juror that he indicated were significant. Now, when this evidence was discovered, and it was part of a filing that was seeking to have the case placed back in the Court of Common Pleas while the Castile issue is still being litigated, so that became part of a court filing. Trial prosecutor Joseph McGill submitted an affidavit in this proceeding to try to explain away these extremely inculpatory pieces of evidence of prosecutorial misconduct in terms of fabricating evidence and in terms of keeping Black people off of the jury. In that affidavit, he said that there was no promise of payment, but instead that after the trial, Robert Chobert approached him and inquired about receiving money for him missing work for coming to trial to testify. McGill in his affidavit said he would look into it, but it was after his testimony, so there was no promise. He wasn't actually going to look into it because that's not the sort of thing he would do. So his affidavit is, I just lied to him to get him to go away, essentially. And then he said he never spoke with him after that. The problem with that position is that it's flatly contradicted by Robert Chobert's testimony in a 1995 PCRA proceeding, in which Mr. Chobert says that he shook hands with McGill and never spoke to him after the trial whatsoever. And furthermore, that Robert Chobert did not miss work during the trial. He was put up at a hotel under guard by the Philadelphia Police Department, and they took him to work every single day. So he can't be seeking money for missing work that he did not, in fact, miss. Now, McGill also said that he was keeping track of the race of jurors, but that was just the standard practice at the time. He doesn't explain why or towards what ends, and he said this was part of a jury questionnaire form that the courts put forth. The courts didn't actually put this forth in 1982. This was just factually inaccurate. And it really flies in the face of US Supreme Court precedent and Pennsylvania Superior and Supreme Court precedent that have recognized that race-conscious jury selection is impermissible. And this is all the more striking because 11 of the fifth, well, let me mention all the lawyers in a case, whether it's a prosecutor or a defense counsel, get something called peremptory strikes. That means they can just throw somebody off the jury without having a legal basis. It's kind of a license to discriminate, but they can't discriminate on the basis of race. So 11 of the 15 peremptory strikes used by Joseph McGill were used to exclude Black people from the jury. And far, far less were used to exclude white people from the jury. So this is not something that's statistically likely to happen. And furthermore, his notes show that there were people who were otherwise similarly situated in terms of where they lived in Philadelphia, their employment status, their familial status, things that McGill said he cared about. But when you put them next to each other, the Black jurors or potential jurors were the ones that McGill struck to keep off the jury. So this is all very potent new evidence that was improperly rejected by the Court of Common Pleas without an evidentiary hearing, and that's what we are appealing.
Okay, Bret, let's try to deal with the elephant in the room here. Last year, in the many elephants, the herd of elephants in the room. In 2023, in Philadelphia, 15 people who were wrongfully convicted, serving anywhere from 8 to decades in jail, were exonerated. They were released because courts and the DA's office determined that they were wrongfully convicted. When you look at the reasons that these exonerations took place, two reasons are consistent in every one of them. One is the prosecutorial misconduct, and two was withholding evidence. This evidence that you just talked about, the letter from Chobert to the prosecutor and the prosecutor keeping notes, was improperly withheld from the defense for 36 years. That would seemingly, to laymen, qualify as improperly withheld evidence. Why is it that 16 people last year, and over now from today going back to about 2018, there's been about 40 people that are exonerated? Why can they get relief and Mumia cannot?
That is a good question. Mumia's case is inherently political in the way that he has been targeted by the police who knew who he was when they saw him on the scene, through the prosecutor's closing argument that improperly and unconstitutionally lifted up his Black Panther politics to argue in favor of the death penalty, all through an appellate process that has been defined by the way it has become a political contest between critics of a racist punishment system and a white lynch mob that goes by the name of the Fraternal Order of Police. It has become something that they organize around to further their own ends. Now, in Mumia's case recently, under the Krasner administration, there was something called a King's Bench petition that was filed. And this is very illustrative of the pressures that are on Krasner's office in shaping how he's thinking about these cases, this case in particular. In that King's Bench petition, the widow of Daniel Faulkner, Maureen Faulkner, asked the Pennsylvania Supreme Court to intervene and remove the case from Krasner's office, arguing that he wasn't properly defending the conviction. Now, a King's Bench petition might sound strange. It is strange. It's some ancient writ brought over from England. It allows the PA Supreme Court to take any particular case for any particular reason on its own original jurisdiction, without any limitation whatsoever. And what the PA Supreme Court did was they indulged in the Mumia exception. They created a very distinct rule, which was they allowed a victim to have standing in a criminal case. Anybody that knows anything about legal process knows victims are not parties in criminal cases. They do not get to select legal arguments. They do not get to bring charges. They do not get to have any control over trial or defense strategy. They're just not parties unless it is this particular case. The PA Supreme Court took the petition and appointed a special master who did an investigation into Krasner's independence, whether he had a conflict based on very alleged, speculative, tertiary type of connections with people arguably connected to Mumia's case in the past. Special Master found that there was no legal conflict, but the opinion that came from the PA Supreme Court, which dismissed the case, allowed Krasner to keep it, contained commentary from certain justices that they might feel differently if Krasner was not prosecuting this case vigorously. So that is a very stark, unprecedented example of how the courts were signaling to Krasner's office that if you do not exercise your prosecutorial duties in the way that we think would be appropriate in this case, we might simply take the case from you. So Krasner is no doubt assessing how he looks at this case based on how he is trying to establish legitimacy for his overall approach to that office. And you'd have to ask Mr. Krasner why he's taken the positions that he has in this case, but it seems that there would be a reasonable belief that he has no problem not extending the reforms of his own office to this particular case as a question of political calculus.
Okay, well, thank you. There's Amnesty International wrote an incredible report on the Abu-Jamal case in February of 2000. We're talking about over 20 years ago. And they laid out a lot of these things, including the improprieties with the Pennsylvania Supreme Court. When Abu-Jamal's case went up to the court in 98, when they made their decision, this business about DA Castile, he said, I'm not going to recuse myself, although I was the DA and I oppose his appeals. But why are you picking on me? Because 4 other members of the court also took money in support from the FOP. So you had 5 members of a 7-member court under the yoke of the Fraternal Order of Police, and that masquerades as justice. Well, thank you, Bret. Appreciate your insight on this matter, and we'll move on with the program.
All right. Thank you, Linn.
Thank you. I'll take it from here. I'm so happy to be here. Y'all, free Mumia Abu-Jamal. It's great to be in this room with, over 120 people. Thank you so much. My name is Jennifer Black. I'm going to be talking to Saleem Holbrook about building international support. And I think Linn made such an important and absolutely accurate comment when he said that the support for Mumia is global. That's something I witnessed firsthand. I happened to be in London, England, in the time leading up to those scary weeks leading up to the first signed execution warrant in 1995. And there was a 24-hour vigil in front of the American embassy, hundreds of people coming through every day, getting news. The internet was just a new phenomenon then. Funny to consider, getting news every day of events happening all over the world. And that is actually the focus of what I'm going to be talking to Saleem about. Saleem, such a beacon and inspiration, and all the work you're doing on behalf of the abolition movement in Pennsylvania with the Abolitionist Law Center and so many other groups and people. So I want to ask you, Saleem, last year, you and other representatives from the abolitionist movement in Pennsylvania, including a large contingent from ALC, trekked all the way to Geneva, Switzerland, and testified in front of the UN. If I'm not mistaken, I believe it was the Human Rights Council, the UN Human Rights Council, to talk about death by incarceration policies in Pennsylvania. So can you give us some idea why it was so important to do that and how it went? Just basically how it went, please.
Yeah, thank you. Just for context, it was a Human Rights Committee, and we were talking about the United States overuse of death by incarceration, life without parole sentences in the United States, as well as its larger use of discriminatory, disproportionate sentences for minority communities in the United States. One of the things that really stood out over there is that while we were talking about the use of mass incarceration and death by incarceration sentences in the United States, and also narrowing it down to Pennsylvania, while I was over there, being in that international space with international human rights advocates from around the world, one of the things that really struck me was this is a prime opportunity to center political prisoners in the United States, right? Specifically in my home state of Pennsylvania, mainly because I was in the cages with many of them. Many of them were my mentors. So as a result of that, we sought to strategically insert the conversation of political prisoners into the larger problem of death by incarceration in the United States. And that is that the majority of political prisoners in the United States, whether it's Mumia Abu-Jamal, whether it was Leonard Peltier, whether it was Mutulu Shakur, Sundiata Acoli, Russell Maroon Schultz, and many others were serving these death by incarceration sentences. And these were essentially state violence, right? When you sentence someone to spend the rest of their life in prison, you give them no opportunity to demonstrate remorse, rehabilitation, or redemption. Essentially, you are subjecting them to violence. It's a terminal sentence. So we use that as an opportunity to center Mumia's case specifically because of the international support that at one time, the support is there, but I remember there were millions in the street for Mumia in the 90s. So our participation in the United Nations contingent, the United States contingent that went to Geneva to condemn and hold accountable the United States for its practice of sentencing so many people, over 200,000, to death by incarceration in the United States. We saw that as an opening, right, to center the issue of political prisoners, specifically Mumia Abu-Jamal, who was serving a death by incarceration sentence. And that opening also was inspired by the opening that resulted in my freedom, as well as Ghani's freedom, on this call, and hundreds of others in Pennsylvania. And that is, there was a time when children in the United States were sentenced to mandatory life without parole sentences. I was one of them. Pennsylvania had over 500 of them. In 2009, my sister went to Geneva to testify as a family member who had a loved one serving death by incarceration, right? The support that we built internationally to compel the United States to end the practice of mandatory life without parole sentences of children was something that motivated Ghani and myself to look at this differently and say, okay, there's a gap. You know, that's one thing that prison teaches you, is to find a gap, right? And so we were like, okay, at this moment right now, there is a gap, and we need to be strategic and exploit it and use this opportunity in front of the United States to not just center death by incarceration and condemn the United States for the use of this practice, but it's also a gap for us to lift up our forgotten political prisoners, right? Because Ghani and I went to prison for dumb shit, for social offenses that we committed as juveniles, as kids, caught up in the street life. Mumia and many of our political prisoners went to prison for fighting for our freedoms, fighting to make this place, this country, our neighborhoods, and our communities a better place. So we saw that as a gap to insert Mumia's case. And again, I'm not diminishing the fact that the international support for Mumia has always been there, but it is not there to the extent that it was 20 years ago when I was in the cages and I was watching TV, millions and tens of thousands across the world hitting the streets from Mumia Abu-Jamal.
You know, it's so interesting that you said that prison taught you to find the gap, because I remember the first time I ever heard about this consideration of taking it to an international, you know, taking it out of the realm of domestic or regional rights or state rights to an international stage was actually in the visiting room of SCI Rockview, talking to Shakabuna Marshall. So I guess I'm saying that, I'm going to preface that by just saying, you know, how do we make sure to center the strategies and ideas and wisdom of incarcerated people in this struggle to build international support? You know, how do we translate those, you know, that knowledge and that wisdom of finding the gap and making sure that incarcerated people and formerly incarcerated people and their families are on the forefront of building our strategy for this movement?
Well, what I want to do is bring that back to Mumia's case in terms of finding the gap. So, for example, as a result of our testimony, our not only our lived experience testimony, which is also important, but also the data testimony, which is more important, right? It resulted in the United States issuing a set of findings. And one is that the United States use of death by incarceration was a human rights violation. Two, that the United States, based on that violation, should issue a moratorium on the use of death by incarceration, life without parole sentences in the United States. And then three, that the United States should provide avenues of release for all people serving life without parole sentence in the United States, including relief through the courts, executive clemency, commutations, or pardons. That last part for us is what the latter two are the focus for us. Now, listen, we all know that the United Nations recommendations do not have what I would like to say teeth or binding in the United States, right? But that does not mean that we should not incorporate that in our advocacy. So one of the things that we wanted to do with this seminar, this webinar, is to share this and ask people, hey, look, people need to start reaching out to legislators. People need to start reaching out to the governor, to the media. People need to start reaching out to their churches, to their communities, not just educating people or sharing with them these releases from the United Nations, but also asking those in power and those with influence to start the process of enabling release for people who are serving those cases based on the United Nations moratorium or recommendations for a moratorium that they issued. And someone is going to drop that into the chat. I hope that they will drop that into the chat, the articles about the UN trip that we were on, as well as the moratorium, so people can cut and paste it and take it back. Because, as I said earlier, when the UN in 2006 and 2008 said that sentencing children in the United States to life without parole sentences was torture, the United States was under no obligation to that. Many politicians and people in the United States just blew that shit off. Like, yeah, all right, that don't have no teeth. We're not going to pay attention to it. But it was our family members and it was our movement and our attorneys that took that and ran with that, right? And we said, you may not want to acknowledge this, and yeah, there may be no binding for it, but we are damn sure going to make sure that people hear it. We're going to make sure that people in power hear it, and we're going to organize and mobilize around it. So that is what we wanted to come out of Geneva, and that is what we are asking to be centered, right? It's not about me going there and telling my story, because you could literally, unfortunately, just pull any brother off the streets in Philadelphia and say, share your story of incarceration or mass incarceration. That's how prevalent it is. What we wanted to come out of it was, the results, and we believe that's how you center the work, the experience of formerly incarcerated people, but more importantly, of political prisoners, right? So that's what we want to do with that information that came out in Geneva. Again, under no illusion that this is anything binding by the United States, but our objective, right, to complement the legal, like we did with children sentenced to life without parole, which was a violation of international law. You need a very strong advocacy campaign composed of media, community, religious, whatever you have it, advocating and pushing on those in power to end this practice that has been found to be a violation of international law. Not unconstitutional, because like you said earlier, right, our human rights transcend the Constitution, and the practice of death by incarceration, specifically in the case like Mumia Abu-Jamal, where it's without question that whatever happened that night, Mumia not only had nothing to do with it and was innocent, but there are just too many holes in the prosecution's case to allow a man to be in prison for 50 years.
That's right. And I just want to remind, if people don't know, I just want to remind people that, Mumia has always recognized and just been very heartened by the amount of international support he has received. As we've said, it's been significant and consistent. I remember that the first language he ever studied in prison was German, and it was so he could communicate with all his supporters in Berlin. He still has a strong contingent of consistent support in Germany. Of course, we have the unflagging advocacy of Julia Wright, and from France, and the Libérons Mumia Collective. As well, we have Muriel Fanon Mendez France. Also from France, we have so many committed people from Mexico, from the Netherlands, from Brazil, literally, as Linn said, all around the world. And, Mumia has always recognized that, always been very heartened by that. And, we just want to continue to build on that support, of course, and work cooperatively and effectively across international lines. This is a global movement. So thank you so much for all of that information and advocacy. I think I'm going to shift focus a little bit now and move the conversation away from the global and onto something a little bit more regional. And that is about the issue of commutation here in Pennsylvania, and how commutation operates, why it's not an effective pathway for release. As I understand it, Saleem, that commutation is, being granted commutation is currently the only chance lifers have to walk out of prison. Can you please just give us a rundown about what commutation is, how it works in Pennsylvania?
Yeah, I just want to clarify that it's the only chance if after your legal avenues have been appealed, because all sentences in Pennsylvania for life, for first and second degree murder, with the exception of children, is life without parole. So commutation in Pennsylvania historically was something that was used as a release valve for the lifers population in Pennsylvania. There was a time in the 70s when Pennsylvania had maybe 600-700 lifers, that close to 30 lifers a year were being released through commutation. And there was an expectation that after maybe 20 years, in some cases less, of a life sentence in Pennsylvania, you would be granted commutation if you had demonstrated remorse, demonstrated rehabilitation. That changed in the 80s. That changed in the 80s with the rise of mass incarceration. It changed with the war on drugs, with the war on crime. And then it really got worse. For example, in the 80s, it petered down to single digits. However, in 1993 and 94, it really got worse, particularly with the rise of mass incarceration on steroids, the 1994 crime bill. But also, unfortunately, in Pennsylvania, you had the case of the McFadden case, where someone that was a known crackpot, someone that was a known informer, was granted commutation. He had helped the prison staff at the Camp Hill riots, testified and gave evidence against people who arose up. And in exchange for that, as well as helping out on an assault case in Western Pennsylvania in a prison where a prisoner allegedly assaulted a prison captain. He jumped in and assisted the captain. In exchange for those favors, he was pushed to the front of the commutation line ahead of a lot of more qualified people who had actually rehabilitated themselves, acted with dignity in prison, and showed remorse, and he was released. And unfortunately, he went home and killed 4 people. There's no other way to put it. You could look up the case, and that basically was the end of commutation in Pennsylvania. It was also the end of parole, or any chance of parole for a long time, because many of us who were in prison remember there was the prospect of a bill for lifers back in the early 90s, but that killed it. That shut down commutation for 26 years in Pennsylvania. Literally, no one got out. The gate started opening in the mid-2000s, and our partners at Amnistad really kicked it open in 2018 and 2019 by waging campaigns to open up the board of pardons, to the point where, as you shared, Jennifer, I think in the last, if I'm correct, since 2020, is it close to 50 people were lifers who received commutation, which is really significant when you think that for 26 years, no people received it. However, I gotta really put this in the context that 50 people is great, but there are 5,700 people serving life without parole in Pennsylvania. So that's just the context there for that. So as we say in our shops when we're dealing with commutation, it's a lottery. In order to receive commutation in Pennsylvania, you have to receive, first of all, the governor is taken out of the equation. So any ideal that, I could pick up the phone, or someone that I remember I was appointed to the Shapiro's Transition Committee, and people were asking me yo, you can get our people pardoned. And it was no, it don't work like that. The governor is taken out of the commutation process for many reasons. One of the reasons that was because of, in the past, it was corrupt. People could buy pardons. So in the years ago, and I'm talking about before my time, before Linn's time, I think this might have been the 30s or something like that, a law was enacted that took the governor out of the pardons and commutation process, so people couldn't buy pardons and commutation. And it appointed a 5-person board that acts as the gatekeeper to the process. And right now, that board consists of 2 elected officials, the lieutenant governor and the attorney general, which really politicized the board of pardons, because you got 2 people who are elected, who every decision they make now is on that board is is this person going to ruin my chances for running for another office if they mess up? The other 3 people are members from the victims advocate community, a corrections expert, which means a former warden or former guard, and a psychologist, which very perversely is a child psychologist who now occupies that position. And I'll save that for later on. But these 5, in order for a lifer to receive commutation, they must have a unanimous vote from these 5 individuals. And what that means is any one of them can say no, and it tanks you. Before the McFadden case, the individual I talked about who received commutation, it was a majority rule. And basically, if you got 3 out of that 5, you was good. So, if you got 3 votes and 2 were against you, you were good. You were going to make it out. Your petition would make it to the governor's desk. And 9 out of 10 times, the governor would sign it. There were very few cases where the governor did it. There were some, but I'm not going to get too deep into that right now. Now, however, you got to have a unanimous vote. So you have to have all 5 of those individuals vote yes in order for your pardon application to make it to the governor's desk to sign on, which really makes it extremely difficult, but it's not improbable. So I want to make that clear that it's not an improbable, it's not an impossible process, right? But it is difficult. And like we say, we call it a cruel lottery because a lot of times it's either who you know, how you operate, and whether or not you know how to play the inside game that is going to determine whether or not you receive commutation. And then if you do all that, you still don't know, because it only takes one to tank it. So we've had many cases where all the stars aligned. The individual had the victim support, the individual had the prison support, the individual had community support. Everything, perfect record, went up and were shot down. And then there have been other cases where they weren't shot down. A lot of times it had to do with how you were received in the interview, how you were received by the Board of Pardons, or who you had advocating on your behalf. Sometimes there's been times when who people had advocating on their behalf tanked them and shot them down. So, that's context. And look, like, again, there is the Mumia rule, and that is Mumia is different. So even with commutation, that is something that we have to consider, that if this is a route that is chosen, if this is a route specifically that Mumia chooses, because this is not our call, this is Mumia call. If this is a route he chooses, then we have to really take that into consideration, that it's going to be a challenge, but, again, we're up for it. We face these challenges with the Move 9, with Russell Maroon Schultz and many others, but we definitely understand that it's going to be a battle if that's a route that we have to take, not just because of the political opposition, as well as the opposition from the FOP, but also because we got to really make sure that we have all of our cards lined up if this is a route that is going to be taken.
Thank you. Thank you, Saleem. So just to recap, 5 people, and I think those 5 are the Lieutenant Governor, the Attorney General, clinical psychologist, I believe, a correctionals expert, and a victims advocate. 5 people, a board of pardons consisting of those 5 people make these decisions for, anybody's freedom, yay or nay. And it's safe to say, based on what you've just explained, that we might consider this to be political. They might have some political interest in these determinations or decisions, or they might be beholden to some kind of political leverage or political interest.
Yeah, one quick thing
yeah.
to say too is that, when we moved for Russell Maroon Schultz compassionate release, one of the things we did was went around to a lot of the politicians that we have political capital with, and were able to get support letters requesting his release. And some of those, they were purely transactional relationships, that we had people in their districts who were going to go out, knock doors for them, get petitions for them, work to get them reelected. And they were like, oh, that's cool. Or we have done it before, done it for them previously, right? So these are things that you have to think about when you're doing something like, whether it's commutation or compassionate release, in that if you're going to be looking for political cover, because that's what judges and other people look for, you're going to have to think transactional when you're playing the inside game, with whether it's commutation or compassionate release.
Thank you. This is actually a really good segue to hand this back to Bret and Linn, because they're going to be talking about this compassionate release issue. But right before I do, I just want to throw one question out there. Is is commutation one of the pathways we should be considering for Mumia? Despite the hurdles you've just explained, is this a pathway that we're considering?
For compassionate release for Mumia?
No. We're not compassionate release, commutation.
Well, that's Mumia's call. Again, see, let's say this, like, if Mumia says move for compassionate commutation, then we are going to move for commutation, right? And let me just also say this, right? Because I we've been doing this work for years, right? We know that Mumia is a political prisoner, right? If we want to play the game of militant posturing and shit like that, we can do that for another 100 years, and Mumia is going to be in prison, right? What we are doing, what Mumia is doing, and what people who are serious, right, about this political struggle are doing, is we are looking for gaps in the system to free Mumia, particularly legitimate gaps in the system, because that's who has the keys. And that's what we have to target and attack, right? So I do want to center that we could sit here and go in on white supremacy. We could sit here and go in on and use all this rhetoric that essentially has us here today, 50 years after Mumia is in prison, and 50 years after many of our political prisoners are still in prison, or we can get serious, right, and start organizing and moving power. So that's something I just really want to center, because a lot of times, you know, we've been on that treadmill of rhetoric as if we're still living in the 1960s or this is still 1968, and it's not the case. You know, so what we're trying to do, particularly now because of this sense of urgency, right, is free Mumia Abu-Jamal. And I believe wholeheartedly and by any means necessary. But we better make sure that we're strategic and intelligent in whatever practice, you know, we do. So that's something I definitely want to center, because we ain't got time for no militant bullshit or posturing. You know what I'm saying? Like I used to say in prison, you know, actually, I'll just turn it over. I don't want to go into that. You know,
Okay. Well, basically, we're finding the gap. Let's just sum it up as we're gonna find that gap. Okay, and we're gonna free Mumia by any means, including you know, all these legal channels. The Mumia exception notwithstanding. And on that note, I'm going to turn it over to Linn and Bret to talk about compassionate release.
Thanks, Jennifer, and thanks, Saleem. Saleem gave us a good definition and working definition of what commutation is. Bret, can you give us a definition of what compassionate release is and how that is different from commutation, or is it different from commutation?
Well, it's quite different from commutation. And it's basically one of the three mechanisms that you have if you're serving a death by incarceration sentence. You can challenge the case in the courts, like I was talking about with you earlier. You count the conviction or the sentence. You can seek commutation or compassionate release. Now, compassionate release is not actually what the legislature in Pennsylvania has called the statute that allows for what is known as compassionate release. And the criteria the Pennsylvania legislature has attached to this is not compassionate, and it's not designed to release people. They call it medical transfer, and it is designed to save the state money in certain extreme instances of health crises that result in a terminal diagnosis. So we began work at the Abolitionist Law Center in compassionate release cases to support Russell Maroon Schultz, who was our first client, who for many of us was an elder, a mentor, an inspirational figure, and a dear comrade. Maroon had terminal cancer, and we moved very quickly because we had been tracking his case in order to get into court to file as soon as he became eligible. And for Pennsylvania to receive compassionate release, you have to have a terminal diagnosis of less than 12 months to live, right? And of course, in the real world, you don't really have some mechanism or some test you can take that actually accurately reflects your lifespan. You know, you're at 11 months and 3 weeks or anything of the sort. So usually there's perhaps a catastrophic health incident, some type of treatment doesn't work, and it can be far less than 12 months. Our first approach with the courts was unsuccessful when we expected that, right? He was not supposed to, in the view of the state, ever be released from prison. They call it death by incarceration for a reason. He had 2 death by incarceration sentences. But before that first hearing was over, we were already thinking about how to question the judge to set ourselves up for the next petition. And we continued to track his situation, and along with movement partners, brought a lot of pressure to bear on the courts as his condition got worse. The Department of Corrections was shown not to be providing proper care. There was a tremendous outpouring of support in the form of letters, courthouse support, letters from politicians, which the judge who ultimately granted the opinion assured us had no influence on her thinking, which, as Maroon said afterwards, indicated that clearly was an influence on her thinking, the fact that she decided to bring it up and speak to it explicitly. And Maroon was released in something that was very bittersweet. He had 52 days when he was not under the control of the prison, and that meant everything to him. And every breath that he took outside of prison was something that was absolutely cherished by him and all those close to him, his family and his movement. And that was a very important case for us to learn about this mechanism for getting people out. And while we're fighting for structural change in the legislature, in the courts, challenging death by incarceration, fighting individual cases, we do have this other mechanism to get people out in a way that is not satisfying given the condition people have to be in, not just with the terminal diagnosis, but if they're to go to home hospice care, you also have to be non-ambulatory. So you can't walk. And it means, but it's a value that we will continue to fight for just as much as possible to get as many people as we can home through that mechanism while we're fighting for mechanisms that prevent anybody from dying in prison. And so a big shout out to our attorneys at ALC, Rupali Rashatwar, Nia Holston, Dolly Prabhu, who have since developed a compassionate release docket, which has resulted in 20 people coming home from the Pennsylvania Department of Corrections, training many other attorneys, and doing a lot of strategic media work in order to lift up the human rights crisis behind bars. So for this to be a mechanism for Mumia, there has to be a predicate fact that none of us want to happen, which is a precipitous decline in health, a terminal diagnosis. He would have to be non-ambulatory if it's hospice care. If it's not hospice care, he has to, at somebody's home, he would have to go to a nursing facility or some other type of institution that would have to take him. We can say that the Philadelphia District Attorney's Office has, in every case where somebody's met the statutory requirements to be eligible for compassionate release, they have supported compassionate release at times in opposition to victims. And there are people like Maroon who have also had cases that are quite controversial and that have provoked victim pushback in cases where victims were police officers, including one of Maroon's co-defendants from his 1970 case, Robert Joyner, including a man, Stanton Story, who was framed for the homicide of a police officer in Allegheny County that saw the intervention in that compassionate release case from former Pennsylvania Governor Tom Corbett, speaking against the release of Stanton Story, who was eventually released. So appeals in the courts, commutation, compassionate release, these are the legally available mechanisms until such time that the legislature would pass a law that would make parole eligibility or other mechanisms that permit for resentencing available. In the federal system, compassionate release after the passage of the First Step Act has allowed for a wider variety of medical conditions to be applicable. There are some possibilities that there could be reform along those measures, but as it is right now, it is a very narrow window that the legislature has created. And Saleem was talking about what gaps can be found. This is a pressure point, to use a term that I know Ghani has used very much. The number of aging people in prisons in Pennsylvania is creating a serious management and cost problem. We're getting requests from people with terminal illnesses every single week from new people. It's this type of pressure that resulted in the former Department of Corrections secretaries, John Wetzel and George Little, signing an amicus brief, a friend of the court brief, to the PA Supreme Court, asking the PA Supreme Court to strike down life without parole for second-degree murder. Mumia is a first-degree case. That was for second-degree murder. That's over 1,100 people. And that's an example of how the pressures on the system, the inhumanity of death by incarceration, the fact that it serves no legitimate public safety interest, but is instead just an arbitrary demonstration of state violence, shows how we can begin to think through applying pressure to create even wider gaps that can benefit more people on the inside, including Mumia.
You mentioned a figure. You said there have been 20 releases. Has that been within the last couple of years, or does that span from when this legislation that was put in effect, whenever it was put in effect?
Right. So that's just what our office has done since Maroon was released in October, there's been 19 others. There's others in the pipeline as well. There's some other cases other attorneys have brought that have gotten more people out. Prior to Maroon coming out, there was an investigation by a journalist in Pennsylvania, Danielle Ohl, found that I think there were only 30 some cases that were granted in the approximately 12 years since the modern version of this law was passed in 2009. So it's ramping up. It's similar to how our movement, being led by people from the inside, began going at the Board of Pardons, pushing for commutation. That opened it up some under Governor Wolf, and that has resulted in very important outcomes for 50 people in that case, right? And just as compassionate release is beginning to open up and more people are learning how to apply for it and fighting to get out and getting out, but it's still a trickle compared to the scope of the problem, but it's creating important momentum and it's building a community of resistance and care that is fighting and learning with each other about how we can go up against this beast and bring people home one by one until the pace picks up in order to begin really emptying these places out.